Something massive just happened, and most people have no idea how big this really is. The Supreme Court has fast-tracked an emergency case that could change everything about gun ownership in America. We're not talking about minor adjustments or small legal tweaks. This is about whether the government can even require you to ask permission before exercising a constitutional right. And the answer that's emerging from the highest court in the land might shock you. Right now, if you live in one of 23 states across America, you need government approval before you can carry a firearm for self-defense. You have to fill out forms, pay fees that can run into hundreds of dollars, sit through training classes, submit your fingerprints, and then wait weeks or even months for bureaucrats to decide whether you deserve to exercise your Second Amendment rights. But here's the thing that nobody's really talking about. 27 other states don't require any of that. In more than half the country, law-abiding citizens can carry firearms without asking anyone's permission. They just do it. And you know what? The sky hasn't fallen. Crime hasn't exploded. Society hasn't collapsed. So why do we have this bizarre situation where your constitutional rights depend entirely on which side of a state border you're standing on? Why should a right guaranteed by the Constitution require a permission slip in New Jersey but not in Tennessee? Why should you need to pay $300 and wait 6 months in New York but walk freely in Wyoming? That fundamental question is exactly what the Supreme Court is being forced to answer right now, and the implications go far beyond just gun rights. Let's talk about what's actually happening in the legal system. Federal courts across the country have been issuing completely contradictory rulings on this exact question. Some circuit courts have looked at permit requirements and said these clearly violate the Second Amendment. You cannot require prior government approval for a constitutional right. That's not how rights work. But other circuits have looked at the exact same question and ruled the opposite way. They've said permit systems are perfectly fine, that requiring licenses and fees and waiting periods is just common sense regulation. This chaos in the lower courts is precisely why the Supreme Court had to step in when different parts of the country are operating under completely different constitutional standards. Something has to give. The core legal argument here is actually pretty straightforward when you strip away all the political noise. The Constitution protects certain fundamental rights: freedom of speech, freedom of religion, the right to due process, the right to bear arms. Now imagine if the government said you needed a permit to go to church. Imagine if you had to pay a fee, pass a test, submit to a background check, and wait for approval before you could criticize the government or practice your faith. Everyone would immediately recognize that as unconstitutional. You don't need government permission to exercise a fundamental right. That's literally what makes it a right instead of a privilege. The government grants privileges. Rights exist whether the government likes it or not. But somehow, when it comes to the Second Amendment, we've accepted a completely different standard. We've allowed a system where constitutional rights get turned into government-issued privileges, where you have to prove you deserve to exercise freedoms that are supposed to be inherent, where bureaucrats get to decide whether you qualify for something the founder said shall not be infringed. And that's exactly what the Supreme Court is being asked to address. Can the government require you to get permission before exercising a constitutional right? And if the answer is no, then what happens to all these permit systems that millions of Americans have been living under for decades? If you're finding this information valuable, do me a favor and hit that like button. It helps more people discover this content, and trust me, this is information every American needs to understand right now. And make sure you're subscribed with notifications turned on, because the legal landscape is changing fast, and you need to stay updated on what's coming next. Share this video with friends and family who care about constitutional rights, because what happens here affects everyone, whether you own a gun or not. The historical evidence on this issue is actually really clear. When the Second Amendment was written, when the Constitution was ratified, permit systems for firearms didn't exist. They weren't part of American law. Citizens had the right to keep and bear arms, period. There was no bureaucratic process, no fees, no waiting periods, no government approval required. That was the whole point. The founders had just fought a revolution against a government that tried to disarm them. They weren't about to create a new system where the government could control who gets to exercise their rights. Permit systems only started appearing in the early 1900s, and the history behind them is actually pretty ugly. Many of these laws had explicitly racist origins. They were designed to keep firearms out of the hands of black citizens, immigrants, and other groups that people in power didn't trust. The system was never really about public safety. It was about control, about making sure that certain people could exercise their rights while others couldn't. And that's exactly the kind of discriminatory system that constitutional protections are supposed to prevent. Even the Department of Justice, in their position on this case, has acknowledged something really important. They've pointed out that we don't require permits for other constitutional rights. You don't need a license to invoke your Fifth Amendment right against self-incrimination. You don't need government approval to exercise your Fourth Amendment protection against unreasonable searches. You don't apply for a permit before speaking your mind under the First Amendment. So why should the Second Amendment work differently? What makes gun rights the one constitutional protection where prior government approval is somehow acceptable? The DOJ's position suggests there's no good answer to that question. Now let's talk about what actually happens in the real world when states eliminate permit requirements. We have data on this. Texas removed their permit requirement. Florida removed theirs. Tennessee got rid of mandatory licensing. And you know what happened? Violent crime went down. Not up, down. The predictions of blood in the streets and Wild West shootouts never materialized. Turns out that criminals, the people actually committing violent crimes, weren't exactly lining up at the permit office anyway. The only people permit systems were really affecting were law-abiding citizens trying to protect themselves and their families. There's also an economic justice argument here that doesn't get enough attention. Permit systems are expensive. In some states, the total cost of getting a carry permit can run anywhere from $150 to over $800 when you factor in application fees, training courses, fingerprinting, and all the other requirements. Now think about who that impacts most. It's not wealthy people living in safe neighborhoods with private security. It's working class people in high crime areas who need self-defense options the most, but can least afford to jump through all these expensive bureaucratic hoops. The system essentially creates a two-tier structure where your ability to protect yourself depends on your income level. Rich people can afford to exercise their rights. Poor people just have to hope nothing bad happens. Before we go further, I want to ask you to do something really important. Hit that subscribe button if you haven't already. We're covering the legal and political developments that mainstream media either ignores or gets completely wrong, and you need accurate information on what's really happening with your rights. Like this video, share it with your network, and let's make sure people actually understand what's at stake here. Your engagement makes a real difference in getting this message out. So the Supreme Court rules that permit systems are unconstitutional. Case closed, right? Everyone can now exercise their Second Amendment rights without government permission. Well, not so fast. Here's where things get really interesting and really complicated. Anti-gun states are already preparing workarounds. They're developing alternative restriction systems designed to accomplish the same goal as permits without technically being permits. And this is where the real fight is going to happen. Some states are planning to rename their permits as certifications or safety acknowledgments. Same system, different name. You still have to apply, still have to pay, still have to wait for approval. They're just calling it something else and claiming it's not really a permit anymore. Other states are looking at requiring approval for ammunition purchases instead of gun purchases. Can't ban the guns? Fine, just make it impossible to buy bullets without government permission. Same result, different method. Then there's mandatory liability insurance. Several states are already drafting legislation that would require gun owners to carry expensive insurance policies. Can't afford the insurance? Then you can't legally own a firearm. It's a backdoor economic restriction that accomplishes through insurance requirements what permits used to accomplish through licensing fees. And there's no limit to how expensive that insurance could become. States could effectively price ordinary citizens out of gun ownership without technically banning anything. Training requirements are another avenue for restriction. States could mandate specific training courses, then control how many training slots are available, where courses can be held, and how much they cost. In theory, anyone can get trained. In practice, if there are only 3 approved trainers in the entire state and they're booked solid for 2 years, the training requirement becomes a ban in everything but name. This is exactly the kind of tactic that some jurisdictions use with other licensing systems, and there's every reason to think anti-gun states will try the same approach here. The point is that even a clear Supreme Court ruling doesn't automatically translate into real-world change. It takes enforcement. It takes follow-up lawsuits. It takes citizens who know their rights and are willing to stand up when state governments try to violate them. The legal victory, as important as it is really just the beginning of a much longer battle over implementation and compliance. Think about what happened after other major Supreme Court decisions on gun rights. The Heller decision in 2008 established that the Second Amendment protects an individual right to keep and bear arms. That was huge. But did anti-gun states just accept that ruling and change their laws? No. They fought it every step of the way. They created new restrictions designed to comply with the letter of the ruling while violating its spirit. It took years of additional litigation to enforce what the Supreme Court had supposedly already settled. The McDonald decision in 2010 applied the Second Amendment to state and local governments, not just the federal government. Another landmark ruling. But again, did that immediately change how places like Chicago and New York handled gun laws? Not really. They adapted. They found new ways to restrict gun rights that they claimed were consistent with the court's decision. Citizens had to file new lawsuits. Cases had to work their way back through the courts. The process took years and in some places is still ongoing. More recently, the Bruen decision in 2022 struck down New York. As discretionary permit system, and established that gun regulations have to be consistent with historical tradition. That should have ended May issue permit schemes across the country. But what actually happened? New York and other states just passed new laws with slightly different restrictions. They claimed the new laws complied with Bruin while still making it incredibly difficult for ordinary citizens to carry firearms. More lawsuits had to be filed. The legal battle continues. Make sure you hit that like button if this video is giving you information you're not getting anywhere else. Subscribe to the channel so you don't miss the follow-up coverage as this situation develops. And share this with everyone who needs to understand what's really happening with Second Amendment rights, because the media narrative and the legal reality are two very different things. So what comes next? That's the question everyone should be asking. If the Supreme Court rules broadly that permit systems violate the Second Amendment, we're looking at a massive shift in American gun law. Millions of people in restrictive states would suddenly have the legal right to carry firearms without government permission. Permit offices would have to shut down. Licensing fees would have to be refunded. Background check systems would need to be restructured to focus on point of sale rather than permit issuance. But that transformation won't happen overnight, and it won't happen without resistance. Some states will comply quickly. Others will drag their feet, test the boundaries, and force citizens to sue them into compliance. There will be a transition period of confusion where nobody's entirely sure what the rules are. Law enforcement won't know how to enforce laws that might not be valid anymore. Gun owners won't know whether they can legally carry or whether they're risking arrest. That uncertainty is dangerous. Nobody wants to be the test case who gets arrested, has to fight charges, and hopes the courts eventually vindicate their rights. So here's what you need to do. Stay informed about the laws in your specific state. Join Second Amendment organizations that are fighting these battles in court and tracking legal developments. Don't assume that just because the Supreme Court ruled something, your local government is actually following that ruling. And unfortunately, be prepared to wait, because the legal system moves slowly even when constitutional rights are on the line. The bigger picture here is about whether we are going to treat constitutional rights consistently, or whether some rights are more equal than others. If the government can require permission before you exercise one constitutional right, what's to stop them from applying the same logic to others? Today it's gun permits. Tomorrow it could be speech licenses or religion registrations. The principle is what matters. Rights that require government approval aren't really rights at all. They're privileges that can be granted or denied based on whether you comply with whatever conditions the government decides to impose. This Supreme Court case, regardless of how it's ultimately decided, forces Americans to confront that fundamental question. Are we a country where the government answers to the people and respects their inherent rights? Or are we a country where citizens have to beg permission from bureaucrats before exercising freedoms that are supposed to be guaranteed? The answer to that question will define American liberty for generations to come. So stay engaged, pay attention. Hold your elected officials accountable. Support organizations that fight for your rights in court. And make sure you understand what's actually happening as this legal battle unfolds, because the stakes couldn't be higher. Don't forget to like this video, subscribe to the channel for ongoing updates, and share this information with everyone who cares about constitutional rights. The fight for freedom never really ends. It just takes different forms. And right now, that fight is happening in courtrooms across America, with consequences that will affect every single one of us.